Good morning. Anything further from you, Attorney Bowser?
No, thank you, Your Honor.
Thank you as well.
Up next, Wells Fargo Bank versus Irene Reyes Gonzalez.
Good morning, Your Honor. James Pocklington of McCalla-Raymer for the plaintiff.
Good morning, sir. And is Irene Reyes Gonzalez here? All right, Attorney Pocklington, I noticed there is a motion to re-include in mediation was filed. And it's my understanding that the defendant now is being assisted in her filings and that she has somewhat recently filed the paperwork that you need, which I believe was forwarded to you by the foreclosure mediator.
The first half of that I was well aware of, Your Honor. The second portion, if the mediator has chosen to reach out, let me take a quick look at a different subsystem because that must have happened very recently because I'm not aware of anything in the court file that would make his involvement public record. It appears that he last terminated the case for mediation after 3 pre-mediation sessions for the borrower's failure to provide documents. Bear with me 1 second while I look to see if there's been any items outside the record. Hold on 1 second, please. Yes, Your Honor, I do see that there were financial documents submitted about a month and change ago. The file was not placed, let me actually, hold on, the file's not currently on hold. Let me see if it was briefly placed on hold and then taken off. Those documents were not sufficient for the lender to have placed the file on hold, which indicates that they were likely an incomplete financial package. Bear with me 1 second while I take a very quick. It does appear that partial documents were received, like I said, about a month and change ago in early June. Ultimately, Your Honor, if our borrowers were here, I was going to suggest judgment with a long sale date because they do have equity and they can certainly discuss things with the lender. Wells Fargo is very easy to work with in terms of document submissions and whatnot, but absent the file being actually placed on hold, I would ask to enter judgment, but give sufficient time to see if those discussions can bear fruit, essentially take, do both so that we're not letting an appraisal or an affidavit of debt go stale, et cetera, et cetera. And I think we could go, I already was planning on suggesting the full 120 under 52-212A for early November sale date.
Yeah, it's my understanding that the defendant now has a support worker who has been working to help her complete the package, and in light of the circumstances, it seems like this would be an appropriate one to get back into mediation and see if we can't, now that there's somebody assisting the defendant, maybe we can get the documents that you need. And so I'm inclined to grant the motion to re-include in mediation and withhold any action on the motion for foreclosure at this time.
Absolutely your discretion, Your Honor. You clearly know more about the fact pattern than is in the record, so yeah, or than I do. Thank you very much, Your Honor.
Thank you as
So
well,
off
sir.
then today.
We're off.
Thank you.
Thank you as well, sir.
Right, up next, Carrington Mortgage Services LLC versus Eric Buckland.
Morning, Your Honor. Attorney Vincent Averamo for the plaintiff.
Good morning, sir. And is anyone here on behalf of, bear with me. Sorry, I switched screens for that last one and it threw me off. All right.
No problem.
Eric Buckland is present.
All right, is there anyone here? There we go. Eric Buckland, you're present, sir?
Yes.
All right, and is Nicole Carden present? All right, here's the situation for Mr. Buckland's benefit. This is a matter in which defaults were previously entered against all parties, the Secretary of HUD for failure to appear, and against you and Ms. Carden for failure to plead on January 8th. There's an affidavit of compliance with EMAP, and I make a finding as such. And so we're prepared to go forwards with the foreclosure today. But since you're with us, Mr. Buckland, do you have anything you wish to say, or do you take any position in that regard, sir?
No.
All right.
Nothing to say.
All right, based on that, I make a finding, based on the appraisal, that's a fair market value of $230,000. Sorry, you still with me, Mr. Buckland?
Yes.
Did you say something else?
No.
All right. So I make a finding of fair market value of $230,000. Against that, I make a finding of a debt of $217,373.74. There is therefore some equity in the property. I'm going to order a foreclosure by sale, therefore, on October 24, 2026. I'm going to award attorney's fees in the amount of $5,000, an appraisal fee in the amount of $350, and a title search fee in the amount of $225. Anything further on that one, counsel?
No, Your Honor. Thank you very much.
All right. Any questions, Mr. Buckland?
Yeah, yes.
October 24th is that when the house has to be.
Is October 24th, is that the date when it has to be sold?
Right. So you still have an opportunity before then to make any arrangements you could possibly make, perhaps to work this out with the lender. But there will be an auction at that date on the property, at which time the property will be sold.
Okay.
Any further questions, sir?
I have one more. What's the question?
Since the house is occupied and children, will there be a notice?
Since the house is being occupied with children, will there be a notice?
What do you mean a notice, sir?
Well, it's just when do they need to be out?
Okay. Well, what happens is a sign will be placed. I wasn't sure if that's what you meant, but the sale will go forwards. And then after the closing on the sale, all the paperwork is submitted, you would have to be out at some point shortly thereafter, sir. So for planning purposes, you should make plans. I personally would plan on being out by the 24th, because shortly thereafter, you will be, someone else will own the house and you will be out of possession.
Okay. Yeah. Yeah. Okay.
All right then. No further questions on that one then, sir?
No, none.
All right. Thank you, Thank you, Counselor.
Thank you,
We'll
Your
move on to the next matter.
Up next, Nation Star Mortgage LLC versus Justin Kelly, heir of Leishan Kelly.
Good morning, Your Honor. John Fahey, representing the plaintiff. Your Honor, may I request that matter be marked off? Our appraisal is stale, and the defendant's counsel has contacted me requesting a continuance. They're setting up a closing to sell a different property that would result in my client being paid off. So I told him I would request the court for this matter to be marked off. We'll get an updated appraisal, and hopefully this can all work out.
Good. And if it does come back before me, I noted that none of the defendants other than Attorney Valeri were defaulted. So you need to file a motion for default as to Justin, Quasin, Amare, and there's about 5 of them there that need to be defaulted first.
Thank you, Your Honor. I appreciate it.
Thank you. We'll mark the matter off. Thank you.
All right, and up next, Bank of America versus Coastal Toy.
All right.
Oh,
Does anyone-
good morning, Your Honor. My camera stopped working in the meantime.
No problem, sir. Would you just identify yourself for the record?
Yeah, this is Attorney Amir Mian for the defendant, Mr. Toy.
And this is your motion to withdraw as counsel. Is that correct, sir?
Yes, Your Honor.
All right. I found the service has been made pursuant to our prior discussions, and I'm going to grant your motion to withdraw as counsel.
Thank you, Your Honor. Have a great day.
You as well, sir.
Up next, Citizens Bank versus Frank DiMartino.
Morning, Your Honor. Scott Delventura from Tobin and Marone on behalf of Citizens Bank. And we do have an agreement to report to the court.
All right. Well, what would that be, sir? Well, first of all, let me have Mr. DiMartino identify himself for the record. You're muted, Mr. DiMartino.
Sorry. Good morning, Your Honor. My name is Frank DiMartino, the defendant.
All right. I understand that you have an agreement. Is that correct, sir?
Yes, it is.
All right.
We
Would
agreed
one
on
of you
it.
care to? What is the agreement?
Go ahead, attorney.
Yes, Sean. So we have an agreement that the defendant's going to make a payment within 30 days of $4,200. And then once that clears, we'll withdraw the lawsuit. So we won't proceed on the motion for summary judgment today.
All right. So you're not asking the court to enter any orders at this time. You're just asking that I pass the matter in anticipation that I'll receive a withdrawal in due course.
That would be fine, Your Honor. I'm not asking for any orders. We can reclaim the motion unless Your Honor wants to set it down or set down some sort of withdrawal due by or status conference or whatever the court wants to do.
Why don't I set this down for a status conference in 60 days, by which time hopefully we'll have a withdrawal and we won't need to go through this again. Is that
That'd be
agreeable to
great,
you?
Your Honor. Yep.
All right. Any questions in that regard, Mr. DiMartino?
No, not at this time, Your Honor. Thank you.
And if in the meantime you and counsel work it out and the money's paid and satisfied, he'll withdraw the action. You obviously wouldn't need to appear at the status conference in 60 days.
Okay.
Otherwise,
Thank you, Your
good.
Honor.
thank you both very much.
All right. Thank you, Your Honor. Thank you, Mr.
Thank you.
Martini.
Okay, up next, One West Bank versus Linda Policia.
Just before we get to that, do we still have the Hector Cruz Marcial matter? Nope, that's not until 12 o'clock.
Yeah, no. Yep.
All right. On One West Bank, Attorney Pocklington, would you identify yourself for the record, sir?
Good morning again, Your Honor. James Pocklington of the Calaramer for the plaintiff.
Good morning, sir. And Miss Pelletier, are you with us?
Yes, I am, Your Honor. Good morning.
Good morning. And just for formality's sake, would you identify yourself, ma'am?
Linda Pelleccia.
All right. All right. This is your motion to dismiss. Miss Pelletier, alleging the court lacks subject matter jurisdiction over this foreclosure action because the named substitute plaintiff, One West Bank FSB, is defunct, and you claim that therefore the action cannot be prosecuted in its name. Is that a correct assessment of your allegations on the motion to dismiss, ma'am?
That's correct. That's not the only allegation. And can I ask the court, please, what motion to dismiss are we adjudicating today?
542.00.
542. Okay, the court did deny that prematurely before argument, and I don't believe the record's been cleared. I asked for case flow requests to have the record cleared, and I also asked for additional case flow requests. I haven't got a response on any of them as of yet today. So I just want the record clear that your original denial to 542 is moot, and we're moving forward today with that.
We're definitely moving forward because you've not requested oral argument. I may end up, should I grant your motion to dismiss, I might have to vacate my prior order. On the other hand, if I deny your motion to dismiss, I would issue a decision in that regard, but it may or may not require me to vacate the prior order. But that's not the point. What we're here on today is argument on your motion to dismiss as you requested.
Okay.
And before we go any farther, ma'am, I'm not seeing you on video. Have you got your camera turned off intentionally, or do you wish not to proceed with the camera?
I'm on via landline, sir.
Okay. All right.
Okay.
All right. I want to just state for the record that Ms. Pelletier, you submitted, I don't know, 500 pages of documents over the last couple of weeks in response to my directive that anything that you were to wish to file be done by July 13th, which you did. I have all of your documents in front of me. I've looked at everything that you've submitted. And so therefore, since you're the moving party, what would you like to be heard on today, ma'am, in regards to your motion to dismiss?
Okay, well, that's what I'm trying to get based on. I just want a clarification, because if you don't vacate that original order, the date of denial is going to definitely clearly prejudice me. But, so, the fact of the matter is, I'm appearing as a pro se, and I asked the court to dismiss the action because the plaintiff lacks standing as a matter of law. The plaintiff must possess a valid interest in the loan every foreclosure case commences. This lawsuit was filed on February 8th, and the plaintiff's own documents and the federal government records proved that the entities in this chain did not own the loan when they sued me, did not own the loan during litigation, and tried to retroactively manufacture paperwork a decade later. The absolute source of truth in this matter is the official FDIC FOIA response regarding my specific loan number. That is in the record, Your Honor, within the documents that I sent. I will clearly, if you like, identify each and every page that I will reference if you choose, or I can actually submit that to you to make your view of that file easier. That's your choice. I appreciate anything in this matter that you do or allow me to do, because the reality is the loan was sold. IndyMac Bank sold the loan on April 1st, 2008 to Round Point for Fannie Mae Trust. Because this occurred before IndyMac collapsed, the loan never entered the FDIC as receivership. There was no 0% transfer to anybody. The FDIC explicitly confirmed it held 0% assets of the loan and only transferred a servicing number. Because the FDIC only held a servicing number, it had no ownership of the underlying debt, and every single corporate assignment that filed is a legal nullity. The timeline of assignment. One West Bank, first of all, filed a substitution of plaintiff. I wasn't in the case. I didn't enter the case until later in 2008. All this was done prior. They filed a substitution of party through merger. That was an outright blatant lie to you, sir. FDIC doesn't merge with a financial institution. It was a sale for one for two. One West Bank didn't even exist until March 19th of 2009. So they presented to you as merger to allow the court to think that they're attached to this when they weren't. The One West Bank didn't exist prior to the commencement of the action, and they don't exist now. And every other document that you have, Your Honor, identifies a default date of April 1st, 2008, which comes after the commencement of the action. So we have a situation here. IndyMac sold the loan on April 1st, 2008 before its demise. None of the claims in the court by One West are accurate or true because it's an impossibility if the asset wasn't obtained by the FDIC. The FDIC does have the records, though, but they never got the asset. So the asset never went to IndyMac Federal. IndyMac Federal never gave it to One West Bank. So all of that is a nullity. Every claim in this court is a nullity. Then, out of the clear blue sky, 2018, October, there's an assignment of mortgage filed in the land records. FDIC as receiver. False fact. The FDIC never got the asset. To One West Bank FSB that hasn't existed in One West Bank's name since 2014 and 15. An assignment of mortgage. Then One West FSB that doesn't exist, nor got it from the FDIC, transfers it to a trust, Wells Fargo, as trustee for the Lehman Trust in 2018 on a trust that closed in 2006. Now, they claim out of the clear blue sky that the trust always owned the loan from inception. Well, that was never claimed in the court. Actually, it was actually denied that any trust existed in this matter. There isn't a true fact in front of this court from the first day to the present day. This case needs to be dismissed. Look, I'm not looking to get away with anything. The law is the law. The party doesn't exist, didn't exist upon commencement, never got the loan. The loan sits with Fannie Mae, and FDIC is the record keeper of IndyMac financial documents and records. And you have that evidence certified in front of you, Your Honor. So there's no case here. You know, all they had to do was simply withdraw this damn action way back when and start over. There's even a default letter from One West Bank in July of 2010 that my default date is April 1st, after the commencement of the action. They knew. They tried to get away with murder because I didn't appear. But the fact of the matter is, there was no default. There was no transfer. IndyMac's defunct sold the loan prior to its demise. So none of the matters in front of this court are factually true. This is all hearsay. All hearsay by counsel testifying. Jeffrey Knickerbocker, when Your Honor, another judge asked, Mr. Knickerbocker, is there an assignment to One West Bank? Yes, Your Honor. That was in 2014. The reality is the assignment on the land records didn't come until 2018, 10 years after they got summary judgment. They never had the damn loan. They never got it from the FDIC because the FDIC didn't have any asset. 0% asset they had. The only thing that was transferred was servicing rights. And a servicer can't proceed as an assigner. They didn't own anything. And they're not even in the name. They haven't been in the name of One West Bank since 2014. And they don't exist now as of 1/4/22. And I didn't know any of this, Your Honor. What had happened is I did a FOIA request. I didn't get the answer until after the judgment that entered in April. The answer came to me on April 29th, which caused me to do further research. And everything that I entered into that court is research and documents that was submitted by PHH, who isn't even a party to this case, nor Wells Fargo. Proposed substitute a plant. Proposed. The moving as proposed and a signer as. Neither or is true. Or there's two loans. Which is it? Because I have multiple notes and I have multiple mortgages. And that's also on the record. I just gave Your Honor 2 mortgages. Neither one of them has a Schedule A attached, and it doesn't even have the occupancy agreement rider that's supposed to be attached to the second home rider. It's not even a valid lien. And now they just make up mortgages, certified to be true and correct copies of such. If Your Honor looks at both of those mortgages, you'll see each one of my signatures and initials aren't even the same. Look, I don't like to accuse anybody of anything. I'm not made that way. But fabrication of documents, moving promissory note signature pages on and off, which is evident, attaching addendums to a note that I never signed. That addendum was attached to a different loan that I once had, which I find very interesting, that in the QWR answer recently, they even put in other property HUD ones. And guess what? The HUD one that they put in, that's where the addendum belongs, not on this loan. So they're actually manipulating promissory notes. They're fabricating assignments. They're misleading the court. They're absolute outright lying to the court. I told you last time, Your Honor, I'm not the one lying to you. And I'm not trying to get away with murder. I tried to pay this loan more than once. They can't take it. They started everything wrongly. The bank is defunct, and this went to Fannie Mae, which is guaranteed anyway. The other problem is their own business records are a mess. A mess. I got different debts. I got a debt of $100,000 over than another affidavit of debt. I got statements. Nothing matches. Nothing. Nothing. They've been dual tracking this loan. I was originally discharged in 2009. They're dual tracking the debt. 1, 2. They didn't give me credit for payments I made. And 3, according to their business records, I paid all of 207 and I paid part in 208. I made 20 payments. They got me down as what, 10, 12? I don't even know. But I have the records. There is no default, even according to the business records, that they don't want to give you. I don't know what they're hiding and why, but I'm appalled that counsel is even allowing this. I'm appalled that a counsel, a law firm is allowing this to make a fool out of this court and cause a court to commit a fraud on its own court. I'm embarrassed and insulted. I have respect for the court. Clearly, they don't. I'll still try to rectify this problem.
All right, let's get back to the motion to dismiss. Do you have anything
Right.
else to add in addition to what you
All the
put
following
in your
reasons
three memorandums in support?
Right, I got the memorandum of support. I filed an affidavit, which was never rebutted by counsel, by the way. It wasn't rebutted by, I can't say plaintiff because there isn't one. I'm litigating against a law firm. I'm not litigating against the plaintiff. There was no rebuttal to the affidavit, so the affidavit stands as truth. The motion needs to be, the case needs to be dismissed. By law. You want me to go through all the filings that I just filed? I will go through them one by one, and I will tell you exactly what to go look for. If you'd like, Your Honor.
No, I wouldn't. I frankly, I want to just state that a couple of things by way of background, ma'am. This one already went to trial. It went up to the appellate court. The appellate court affirmed the trial. So anything that you want to offer now that you might wish you'd had, or maybe you wish you'd offered at the time of trial, that ship has sailed, ma'am. This has already gone to judgment. I'm not receiving any new evidence. So
It's everything. Everything I just filed is all new evidence after 22. Everything. After the judgment, everything I filed in that court came after that judgment. And it's all new evidence, Your Honor. Go to the second supplemental. Supplemental.
Instead of me doing that, you listen to me for a second. It went to trial.
Fine.
At that point, the gates were closed. If you had any evidence you wanted to submit, you needed to do it by the time of trial. For you to come in with something after trial and say, oh, why don't we try this over again? Or why don't we go back and revisit that trial? That doesn't work, ma'am. There's been a judgment that's been affirmed by the appellate court. We're not going to retry this matter.
All right, the judgment was affirmed by the appellate court was for sale. Judgment for sale, right?
Yeah, well, that's a whole different animal. That's a different animal. But a lot of your, so we may discuss that at some point when this comes up for, for new dates. But we're not going to, I'm not taking any new evidence that you might, had you submitted to Judge Bolin many, many years ago, might possibly have led to a different result. That's just not the way it works.
I couldn't give him evidence if I only received it on April 29, 2022.
Then arguably, ma'am, maybe you should have requested that earlier, or you should have sought a continuance of the trial because you had a pending FOIA request that you felt was important. I can't even, but that doesn't really matter, ma'am. It went to trial. The judgment was rendered. It's done.
Tried to litigate the case. They wouldn't even let us bring forward our witnesses. The judge never even looked. He actually said he has no intentions on looking at the note and the mortgage. So the note and the mortgage hasn't even been looked at yet in this case. Judge Bolin said he would look at it on the judgment date, but he didn't look at it either, even during summary judgment. Jack Fisher didn't look at the note, and you clearly didn't look at the note and the mortgage either. I mean, this is the most absurd thing I've ever seen in my life. And the fact of the matter is, just because a judgment enters doesn't mean it was entered properly. And if it was entered on fraud, which clearly it was, it could be adjudicated at any time and reversed. And that's what I'm asking you to do. Not only does
ma'am, let's stop her. Take a breath.
Judgment against me because it interferes with my personal life.
Ma'am, there was a judgment. It went up to the appellate court. They affirmed it. You filed for cert. The Supreme Court of this state denied cert. Right. And so now you're asking me to perhaps overturn the appellate court or the Supreme Court? You greatly overestimate my authority in these matters, ma'am. There's a valid judgment that the two appellate courts above me have chose not to touch. I'm not going to touch it.
Okay. So can I ask the court a question, if you don't mind, please? Went to the appellate court because the judgment was in the name of One West Bank FSB. they argued as the plaintiff to be One West Bank FSB in the appellate's court with neither my knowledge nor the appellate's court knowledge that they no longer existed as of January 4th, 2022. They're arguing in an appellate's court. I did not know this, Your Honor. They're arguing in an appellate's court. I can't bring those facts up because that wasn't what the brief was about. I couldn't bring them up. But I'll tell you one thing, I don't believe an appellate court would respect the fact that a plaintiff didn't exist and stood in their courtroom arguing for a plaintiff that doesn't exist in a judgment that they couldn't obtain because they didn't exist.
All right. I think you made that point both in this hearing and in the 3, if not 4 motions to dismiss you've previously filed on that point. So, but the bottom line is, if it wasn't raised, if it wasn't raised at the trial, then the appellate court likely wasn't going to consider it at the appellate level. So they are absolutely correct. I'm sorry, ma'am, I missed what you said.
I said I agree. That's why it wasn't brought up at the appellate court hearing.
Then you waived your opportunity to do so, ma'am. That's what the trial was for.
The appellate court wouldn't address it. They wouldn't address it. You just said they wouldn't address it.
Because you didn't raise it at the trial court level. So your failure to raise that issue took it out of the appellate court's hands, even if there was such an issue. And you're not going to raise it now because judgment's already entered.
All right, so the judgment entered in whose name?
The question now is, you filed a motion to dismiss. And I lost track of how many you filed. But it seems like every time we get close to a judgment, you either file a bankruptcy proceeding or you file a motion to dismiss. But I'm not seeing anything in this motion to dismiss that changes any of the decisions that have previously been rendered. And frankly, cutting right to the chase, you seem to ignore the statute and even the case law on which the plaintiff relies. Connecticut General Statute 52-118 permits a subsequent owner/holder of a loan or note to maintain a pending foreclosure action in the name of the original plaintiff without substituting the current owner/holder of the loan or note in the pending action. That has been pointed out to you repeatedly in the brief submitted by the plaintiff. They also cite the appellate court case of Dime Savings Bank of Wallingford versus Arpaia, which stands for that proposition. And yet you ignore it, or at least you apparently disagree either with the legislature and or with the appellate court, and you feel that this case differs. Since you filed your motion to dismiss, I have to hear it, but I don't see any basis on which to grant it. So can you enlighten me in that regard, ma'am?
Who would you grant the judgment to, Your Honor?
Sorry?
I said, you're asking me, I'm telling you what brought forward new information that I didn't have prior to the trial.
Can't help you.
Thereafter,
That ship has sailed.
The whole case is wrong. Now, you can't, a plaintiff's moving forward that it's not a legal entity. I don't care what rights they might have if they're a legal entity. I don't disagree with that, but they're not. I don't disagree with what you're saying, but they don't exist. They haven't existed and they don't exist. So we're dealing and we're going through a court case, even in an appellate's court, with a ghost. A ghost, literally a ghost. Plaintiff.
All right. I want to give you ample opportunity, ma'am, to explain anything in the 500 pages you filed a week ago, which I have gone through. And if there anything in there and I'm disregarding any new evidence that you feel might have caused the trial court to render a different decision years and years ago. Again, that's not what we're here about. I'm focusing on your motion to dismiss, which is why we're here this morning. And I'm not seeing any reason that you're raising now that A, you haven't raised repeatedly in the past, and or B, that has any legal foundation on which I would possibly grant it. So is there anything else you'd like to enlighten me with that might change my mind in that regard?
Yes, I'll show you, Your Honor. Go to the second, it's docket 573.
Yes, ma'am.
And you could go to page 51. And that should state the FDIC FOIA log response 2022-00104 that was sent to me on April 29th, which was after the trial.
All right. I think I touched upon this, but again, you're proposing to offer new evidence that might arguably have changed the result of the underlying trial.
This would have. This itself would have, because on page...
Let's assume that's the case, ma'am. But it came after the trial.
It came after the trial.
We're not setting aside the trial. We're not reopening the trial. We're not hearing after the fact evidence that after you lost at the trial court level, that you think that had you submitted it, it might have bettered your chances of success. That's not how it works. You get one bite at the apple. You had your one bite at the apple. You went to the appellate court. They agreed that you were given an appropriate one bite of the apple. You tried to go to the Supreme Court. They denied cert. Ma'am, those issues are cast in stone. Whatever you got from a FOIA request thereafter, it's not relevant. It's not, I can't consider it.
You could open a case for new information. This clearly new information shows the whole case is a fraud.
No, I can't, ma'am. There's a judgment. And there's a purpose that I'm not going to second guess a judge who already ruled on this.
I understand you can't, because I understand why you can't. It's not because of the law, but at the point of the matter is, there's no doubt you could open a judgment. You could open anything based on fraud, and this FDIC response shows this whole case is fraud. Shows it all.
Okay.
And the trial court, they put protective orders. They wouldn't let witnesses. They wouldn't let us bring anybody forward. What kind of trial is that? What kind of trial is that?
Arguably, ma'am, those are all good issues for appeal, which you took and you didn't prevail on. So I don't want to hear it today if the appellate court didn't want to hear it in years past.
That's the whole problem. The court never wants to hear the truth. That was the whole problem throughout this case. They never want to hear the truth. So, all right, so the reality is there's another truth factor here, and it's a very relevant one. There's no perfected lien on the property, and I've been discharged. So 4917 goes out the window. There's no lien perfected that's filed in the court or the land records and hasn't been perfected for 20 years. So because there's no perfected lien...
All right, again, ma'am, that really doesn't go to your motion to dismiss for lack of subject matter jurisdiction. And that's what we're here on today, right, ma'am?
Well, that's what I'm trying to tell you. There's no perfected lien. There's no plaintiff. There's no default. There's nothing. There's no valid plaintiff. There's affidavits by people that aren't even in the case. That Judge Bolin even said in 2019, if you go look at this memorandum of decision on page 9, second paragraph, please do yourself a favor. He even said, Wells Fargo has nothing to do with this case, and that One West was always the owner. Well, One West never owned a loan. They were only a servicer. Just go look at that one paragraph.
Again, ma'am, you're asking me to second guess or throw out Judge Bolin's decision and throw out the appellate court's affirmation of that decision. based on new evidence, it's not going to happen.
I'm asking you to look at that because they're filing affidavit presently to re-enter. Presently affidavits. I'm asking you to look at that paragraph because they're filing present affidavits.
All right. Anything further on the motion to dismiss that you'd like to present to the court today, ma'am?
The motion I stand by the motion. I stand by the facts in the motion.
Okay.
I stand by my pleadings. I stand by my recent pleadings that I filed in the supplemental in support of my motion to dismiss. I stand by each and every exhibit in there.
Okay.
I stand by that. And the
All
case
right.
should and must be dismissed. I mean, it doesn't matter of the prior. It matters of the facts today, presently also. It's not just the past, it's the present. They're filing affidavits showing I wasn't in default. They're filing affidavits by parties that aren't in the case. They're filing affidavits by people that Judge Bowen said don't exist and never attempted to collect a debt against me. One West is filing to re-enter. They don't exist. I think those are all factual relevant points, and that's today's date, as of today's date.
All right. Ma'am, I'm going to do, is there any last chance? Anything else you want to add in support of your motion to dismiss?
Anything else? I don't know I can't even imagine what this court's asking me to say, except for I stand by everything I just said. There is no plaintiff in this case. Not a one.
Okay.
Today, I don't care about orders passed. There's nobody here today to ask her to reset. And if Your Honor would have continued the case back in 2025, which I had a prior engagement that I had to attend to, I tried to explain to the court. I would have explained to the court way back when. But you know what? I couldn't attend. I wish I could have, but I could not. I asked for a continuance, and I wasn't there. But at the end of the day, the facts still remain the same. The judgment was entered in the name of a plaintiff that didn't exist. They were defunct and closed as of January 4th, 2022. The same fact stands today. The fact is,
Okay.
there is no jurisdiction this court has if there was no default. No default. The court doesn't have subject matter jurisdiction at any time. The court has jurisdiction to dismiss the case, but the court doesn't have subject matter jurisdiction if case precedent wasn't met from the inception of the case.
Good enough. All right. I think you made that point, ma'am. Unfortunately for you, I disagree. You've alleged that the court lacks subject matter jurisdiction over this action because the named substitute plaintiff, One West Bank FSB, is defunct and the action therefore cannot be prosecuted in his name. In response, the plaintiff asserts that Connecticut General Statutes 52-118 permits a subsequent owner/holder of a loan or note to maintain a pending foreclosure action in the name of the original plaintiff without substituting the current owner/holder of the note or loan in the pending action. The court concurs with the plaintiff in this regard and finds that the current holder of the note in question may elect, as it has done, to maintain the pending foreclosure action in the name of its assigner. And in support of that, I refer you to 52-118 and Dime Savings Bank of Wallingford versus Arpaia, 55 Connecticut App, 180 at page 184, 1999. Therefore, the motion to dismiss is denied. I'll get an order out to that effect later this afternoon.
Okay, Your
Now,
Honor, can I
on to another matter. Nope,
Can I please
that one's done.
interject? The
Motion
assigner.
dismisses, we're done. So now, next issue.
The assigner
Attorney
can't
Pochman.
be West because they never got the loan and they never existed prior to the commencement of the action. So they can move. They can't move as an assigner, and a servicer can't claim owner.
I apologize. I probably wasn't clear. Motion to dismiss is denied.
Uh,
Okay, now we're gonna
Did I-
move on to something else. Attorney Pockington, when you come forwards for a, for refigures in a new law day, or a sale date, I just want to raise this while both parties are present. I note that the appellate court, when it upheld the trial court decision, sent it back down to the trial court for assignment of a new law day. I'm a little bit concerned about a couple of issues, and I just want to raise them for both parties' benefit so when we come back again in that regard. At the time of trial, the property in question was apparently by agreement of counsel, or I don't have the full transcript, but apparently it was agreed at that time that the property was worth $1 million. The most recent appraisal has it at 342, has it for a considerably lower number. And based upon that, it would be appropriate to have a foreclosure by a strict foreclosure versus foreclosure by sale. I would note that since I just want you to be aware that when you come back before me on the motion that I anticipate you will file, it just seemed a little bit unclear because the property is valued $1 million at one point. Now it's being valued considerably less than that. And there may be good reasons for that. I just don't know.
I can
Your Honor,
explain.
just as a procedural question, Your Honor, I thought we were going to be rolling from one into the other today. I was prepared for the setting of either a new sale or a new law day, new findings, et cetera, based off of what we discussed 3 weeks ago. I thought we marked over everything, including I believe it's our motion to open post bankruptcy at, let me just find.
Here's my thought on this one. I agree with you. That initially had been my intention, but until I get a written decision on the motion to dismiss, I can't really proceed. I'm prepared to issue that decision today, but then I can get you on the calendar, again, next week, and we can actually go forwards. But before we do that, I just wanted both parties to be aware that I was concerned about that. I see where, I recall, I've got a copy of it here someplace. The appellate court's decision sent it back to the trial court for the assignment of a new date for a foreclosure by sale based upon its understanding that there was considerable equity in the property at that time. Based on the more recent appraisals, it would appear that a strict foreclosure would be more appropriate. And I'm just wondering, and I just wanted to raise it in advance so I don't surprise anybody in a week, but it seemed to me that since the appellate court sent it back to assign a new date for a foreclosure by sale, question, am I bound to do that, or can I flip it over to a strict?
You absolutely can, Your Honor. I'm grabbing and I know you're saying it so that we can have a chance to just, plan to discuss next week, but if you can give me 30 seconds, I can give you because this was actually dealt with at the appellate level within the last 2 or 3 years because of the changes in fair market value. It was a pair of linked cases. And the appellate court, that's where we actually saw the change. I think Your Honor has seen recent remand orders where they say further proceedings according to law, as opposed to remanding for the purpose of resetting a law day or resetting a sale date. I'm just trying to get those two sites because I remember the cases, I remember the fact patterns, but I do not remember the name. So bear with me one second.
Take your time. This will be beneficial to all of us.
All right, and I could clarify something for the court if you like. First of all, during that original trial hearing, the judge found appraisal Beckett to be unreliable and not credible. The appraised value was agreed upon by all parties. It was actually $1 million plus. They wrote $1 million, but it was $1 million plus because Beckett didn't disclose procedural facts about the property. He still didn't today. So he went right back to what he did when the court first found him uncredible. The plaintiff, I don't know who they are, counsel, waited. That appellate court ordered that order. They didn't move for 9 months. Your Honor woke them up from the dead to move on this case. What did they wait for? What were they waiting for? They ignored a court order from the appellate court for 9 months. what, to try to build up more debt? The problem with this debt in this house, it's not a lot of money, so they couldn't even achieve that. So their affidavit of debt that's done by non-parties in this action is $884. It's still below the $1 million valuation, which is proper, because at the time the $1 million valuation was done, Connecticut properties went up over 30%.
Again, ma'am, this is probably a more
Went
appropriate
down
discussion
90.
for next week when we're
Mine
actually
went-
discussing.
So that appraisal is unreliable, totally unreliable.
Your Honor, the case that you'll want to be familiar with is WABA versus Chase. I'm trying to grab the site. I had to go through my old emails with some discussions with clients about it. Now I'm trying to find a site for you. Hold on one second.
Is that the appellate court?
Yes, Your Honor.
If it's WABA?
WAHBA, WABA.
That's the case. I can find it as well. You know, but I just wanted to, and Miss Pelletier, you can find it as well. Obviously, that's going to be the basis on the argument that even though the appellate court envisioned this would be coming back down to me for assignment of a new sale date, based on the numbers that have been submitted to date, plaintiff's counsel is going to be seeking a foreclosure by sale. So you should likewise be prepared for that.
Your Honor, I have to correct a misspeech. I mentioned earlier that there were two cases pending, or two parallel cases. Suzanne Waba versus JP Morgan Chase was actually the Supreme Court weighing in on the disconnect between the two appellate cases. That was SC 20807 as a docket number. The published in the Connecticut Law Journal, June 25th, 2024. And that has sites to both the appellate decision in WABA, and I believe it references either Firestone or Fireman or something along those lines. That was the other case. I'm just trying to. But Your Honor, just in the sake of trying to think the best way to make Ms. Pelletier not, or to prevent a potential issue, would Your Honor, I just saved the officially released, the one off the Judicial Branch website, advanced release opinions, to my desktop. Would you like me to file that as an exhibit so she'd have an electronic access to that so she can?
I think the more T's we can cross and I's we can dot in this matter, the better it would be. So that'd be great. So the case that Attorney Pockington is relying upon, Ms. Pelletier, he's gonna file as an exhibit, which you'll be able to take a look at, and then you'll be prepared to come back and discuss that with me at the next hearing.
So can I file exhibits from the Supreme Court also on case law?
Of course. Again, we're not going to revisit the issues we've already discussed today, but on the issue of whether there should be a foreclosure by sale or a strict foreclosure, obviously, I'll hear you on that. So let's talk about that. Would both parties be ready if I schedule this for a calendar 1 week going forwards, or would you like 2 weeks to be ready for that, or what's everybody need?
Well, considering I'm a pro se, Your Honor, and I don't have access to their library or staff, the more time you could get, and I'm not trying to delay this. You don't understand. I am not trying to delay this case, but I have to be. It's got to be fair to me. So
Yeah.
don't have to.
I'll reschedule this for another hearing on the issue of what type of sale we're going to have on 2 weeks out from today, which would be August 3rd.
Your Honor, the one thing I will say on that, just so that we can nip potential issues in the bud, I don't have a problem going out 2 weeks as opposed to 1 week, but my current appraisal, which under the standing orders is only good for 120 days, was done in very early April, so we're rapidly approaching its expiration. I just, if Your Honor's willing to bend the standing orders by a couple of days, that date absolutely works, but I don't want Ms. Pelletier being able to come back in and say, standing order say 120, the appraisal was 123, problems. So as long as it's an informed decision to go out that far, yeah.
I appreciate that, and I do modify the standing order on occasion, but I try not to. But Ms. Pelletier, so do you understand what Attorney Pockman is saying? He's okay with giving you the 2 weeks. You asked for a bit more time, but he's not going to allow you to argue that his appraisal has gone stale because of that, and it's a few days over the 120 days that the standing order proposes. So, are you going to have any issue with him using that? That appraisal, even if it's 120 plus days old?
The appraisal, even if he did another one tomorrow, is going to come in the same way, even though it's not reliable. So, I mean, let's be honest with each other. They're going to go for the gusto. They're going to go for the low appraisal, even though we all agreed, including the court, that it was over $1 million back then. So they're going to do whatever they're going to do, Your Honor. So new, old doesn't really matter. Extend the standing order. The whole thing,
All right.
to me, the most ridiculous.
I just want to, so you're agreeing that they can use the appraisal even if it's older than 120 days. Is that correct, ma'am?
I'm fine with that.
Okay. All right. Is there anything else we should discuss today in preparation for that hearing in 2 weeks?
No, sir.
2 weeks. August
And I'm
3rd.
sorry we couldn't wrap it up all today, but I think just to cross the Ts and dot the Is, I want to get a decision on the motion to dismiss filed, and then we can proceed with the next step.
Okay, my last question, Your Honor, is this decision today going to be as of today and not apply to the one that was done a month and a half ago?
That's correct. My decision will I anticipate what you're asking. Does your appeal period start from today or from 6 weeks ago or 5 weeks ago? It'll start from today.
Absolutely, if I'm going to at all, but I would still like to know that answer correct.
Today. Okay.
So
Anything further from either party?
that order is going to be directive as of today.
Will be written and it'll go out today and it'll be effective as of today. Yes, ma'am.
All right, thank you, Your Honor.
Thank you
Thank
both.
you, Your Honor.
Appreciate it. Madam Court Monitor, Mr. Clerk, thank you very much.
You have a great day. Oh, I know I'm going to. They already got the paperwork. I'm just waiting.
Cruz Marcial.
Good morning, Attorney O'Connor.
Cruz
the standard of an attempt to find the last known address. Furthermore, in a clearer parallel to the present case than Ortega, a recent Connecticut Superior Court case in Bridgeport, an opinion on March 18th of this year, Orlando v. Carmona et al. Judge Pavadator held that the defendant's address on a police report from 2 years prior, even with no mention of a planned move, did not meet the last known address standard, and that actual effort to determine whether the 2-year-old address was an actual abode or even a last known address was required. So secondly, the question of whether my client's changing her name obviated the need for further action on the plaintiff's part to conduct service. And the plaintiff claims that from their objection, their memorandum in support of their objection, only 5 days after the collision, the defendant registered with the Connecticut Motor Vehicle Department as Sarah Ann Morrison, thereby making any attempts by the plaintiff to search for an updated address for Sarah Ann Levitt futile. I would argue that changing her last name did not make attempts to locate my client futile, and it certainly didn't make them unnecessary for proper service. That reasoning would suggest that the common act of marriage or divorce would, in many, if not most cases, undo the service requirement to find a defendant's address. I would respond that any proposed precedent which would invalidate a cornerstone of procedural law for a substantial portion of the population is significantly flawed. So I don't think we can say that the mere changing of her name as part of a divorce undid the requirement that there be a reasonably diligent effort to identify her last known address. So that brings us to the plaintiff's actual actions. As they tell us in their affidavit, shortly prior to December 31st, 2025, in an effort to ascertain the defendant's last known address, I searched publicly available records and databases for Sarah Ann Levitt, including but not limited to Connecticut Judicial Branch case lookup, information available through the police report, municipal tax assessor records, property records, voter registration records, probate records, and online public records databases. I submitted this affidavit to provide the court with evidence of my due diligence in ascertaining the last known address of Sarah Ann Levitt. So I would argue that a public record search less than a week before the statute runs does not constitute evidence of a reasonably diligent search for the defendant's address, as the plaintiff pointed out is required. There are many tools available to plaintiffs. Let's see. There needs to be, as the court in Orlando v. Carmona held, a reasonably diligent search has not been met without effort to determine whether the address of the plaintiff was their last known address. And so I think that means some kind of actual probe, which could include a phone call, sending a letter through certified mail to check if the address is current and accurate, hiring an investigator, or even providing a marshal with sufficient time to perform diligent service in which they might be able to identify whether the address is correct. There are many mechanisms that plaintiffs use on a regular basis, all of which would have provided that information. And I would submit that it was the fact that the plaintiff attempted to perform service at the 11th hour that prevented them from finding an accurate last known address, not any action on my client's behalf.
All right. Well, before I even let Attorney O'Connor get into that, based on the affidavit, counsel made various attempts to verify the last known address, albeit, as you say, in the 11th hour, but that's just the way life is with statute of limitations. Sometimes a client comes into your office for whatever reason, you have to do what you have to do. And that means, you may not have the luxury sending a marshal out to Arizona to see if he or she can locate the person. Sending a certified letter to an individual who is a potential defendant, I think is fraught with undue optimism that the person is actually going to respond and say, "Yeah, that's me. Here's where you can sue me at." So just based on what I'm seeing here, the affidavit shows a variety of what I would deem to be reasonable and appropriate steps to try to find this individual, starting with, turning to the police report and seeing the information your client provided, or that at least that the police officer obtained from your client at the scene of the accident. That would be a very logical first step. And it certainly isn't the plaintiff's fault that, and I'm not saying this is any attempt to avoid, service or to avoid prosecution, but she did move shortly thereafter. She changed her name for, I'm sure, absolutely valid reasons, but it made it very difficult it made it more difficult for anyone to find her. And so, before I even let Attorney O'Connor get into this, I look at that from what I've heard and based on the affidavit, it would certainly seem to be that reasonable efforts were made in this case to effectuate a last known address in order to effectuate process. So let me see if there's anything else on. I suspect, based on what I've just said, Attorney O'Connor is probably going to agree with me in that regard. But so I'm just going to turn back to you, Attorney Seminaro. Is there anything else that you want to throw at me that would suggest that these steps taken by Attorney Ruskowski were, I guess it's a judgment call. I mean, ultimately, you may feel that these steps weren't reasonable and appropriate and the ones necessary. I guess I'm tipping my hand. It seems to me pretty appropriate under the circumstances what was done. But is there anything else you want to throw at me before I make that determination?
Thank you, Your Honor. I mean, in the plaintiff drew attention to Canal v. KBE Building Corp. As well in their brief that says that in determining whether a party made a reasonably diligent search before serving a party's last known address, factors such as the use of public information and utilization of other resources can be considered. So certainly these are things that can be considered, but they don't say that those resources would be dispositive to a motion to dismiss. And I think for good reason. I don't think that any one of those resources meets the threshold independently. And as you say, I mean, Your Honor, at the end of the day, it's a judgment call on your behalf. But there are several holdings finding that checking the police report alone is insufficient. I think it can be inferred from Canal v. KBE Building Corp. That they did not, the court in that decision did not believe that public information, such as a records check, alone was sufficient. So the question becomes, are these two resources together sufficient to meet the threshold of a reasonably diligent search for the last known address? Neither of them are interactive. Neither of them in any way check whether there is anyone currently living at the address or make any kind of interactive attempt to contact the defendant, which I would argue is a core element of service, is making sure that there's someone actually there, not just that you have some previous address for the person. But of course, it ultimately comes down to a threshold. Right.
And, it seems strange that when the statute says that for a non-resident motorist, you can serve the Department of Motor Vehicles, it's obviously a streamlined procedure that the legislature has set forth to allow that, to require someone to send out a private investigator or a process server or a marshal to verify the existence of the last known address. It seems to run right in the face of the legislative intent that if you use our roads, you can be served through DMV. That's the way it works. It doesn't require us to do in-hand service or even abode service. So to actually require some higher level of, frankly, you probably have a good argument. Even then, it'd be a judgment call as to whether, if all plaintiff's counsel did was say, look, this was the address on the arrest, the police officer incident report, and took that, even that would be a judgment call, whether it was sufficient. There are some cases that have said it's not. And so probably, but that's not the case here. I mean, counsel did in her affidavit state she took various steps above and beyond that. And, you know, it's kind of surprising that on a motion to dismiss, which is typically an issue based strictly on the law, we do have this situation where it's a judgment call, and it's a very subjective as to, there's no guidance from higher courts that going to tell me I need to check 2 out of 3 boxes, or there's a, you know, cigarette rule that I can apply. This is just whether or not I think it's appropriate. And frankly, cutting right to the chase, I think it was in this case. I think they made appropriate efforts to find the last known address, and that's where they served your client. And unfortunately, I'm disinclined to grant the motion to dismiss. All right. Attorney O'Connor, your argument has been brilliant, but sometimes sometimes it's not necessary. But do you wish to say anything at this point, Counselor? Attorney O'Connor?
No, Your Honor. Thank you.
All right, I'll get a quick decision out. It will not be any length, but I'm just going to put some magic words in there, and I'll get a decision out for you today. Thank you both.
Very much, Your
Thank you.
Counsel?
Yes.
Do you want to do a quick phone call? on the
Yeah,
case?
sure.
Okay, cool. What is a good number to reach you at?
All right. You're back with us, Ms. Lucia Mayo, but you still appear to be muted. And could I ask Lori Vivlamore, would you kindly turn off your microphone? We seem to be getting feedback from somewhere. All right, testing 1, 2, 3. Still getting some feedback. And again, Brenda Vivlamore, you don't have two applications open, a laptop and a computer, or?
Nope.
All right. Well, anyhow, back to you, Miss Lucia Mayo. We can see you, but we can't hear you. And I'm trying to read your lips, but I think you said you're going to withdraw the case. Just kidding, ma'am. There you go.
Is that better?
Much.
Except I have a lot of feedback. That's okay. Clear it up.
All
Let me
right.
just say, I do not like computers, and this is why I like in person.
All right. Would you kindly identify your record or yourself for the record, please, Miss Lucia?
Yes. It's Betty J. Lucier hyphen Mail. At Rich Walsky.
All right. And by any chance, do you have two devices running there, Miss Lucia Mayo?
I don't believe I do.
All right. Miss Brenda Vivlamore.
Oh
would you
my
kindly
God,
put
what
yours on
just
mute for a
happened?
second?
I just lost everything.
Well, we can hear you, ma'am, and I can see you.
Okay. I can't see anything. This is what happened.
Do you want me to sign out, Your Honor, and sign back in?
If you wouldn't mind, that might be helpful. We're getting a lot of feedback from somebody.
Okay, I'll be back.
Oh, there we go. Oh, what the heck? Oh my gosh. Oh,
Miss Lucia Mayo, let me just remind you, everything you say is being taken down by the
yeah,
court
I
monitor.
know.
So
I just,
if you're
oh my
frustrated with
gosh.
your technology, you may not want to share that with all of us.
I really hate computers. Hey, it's not echoing.
Is that
All
better?
right. It is. Now, so far, we've got the plaintiff to identify herself and let's start again. Brenda Vivlamore, would you likewise identify yourself for the record, ma'am?
Brenda Vivlamore.
Right. And I'm using your first name because I see we also have a Lori Vivlamore in attendance. I take it
Yes.
we'll probably hear from her later. All right, initially, let me get both the plaintiff and the defendant under oath. So, Attorney Garcia,
All right. If you both could just raise your right hands for me, please. Do you solemnly swear or sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, nothing but the truth, so help you God upon the penalty of perjury?
I do.
I do.
I'll start with you, Miss Lucia Mayo. Just state your full name, spell your last name, and then state your address for the record.
It's Betty J. Lucier hyphen Mayo. That's LUCIER hyphen MAYO. My address is 890 Upper Maple Street, Dayville, Connecticut 06241.
Thank you. And then you too, Miss Vivlamore. Just state your full name, spell your last name, and your address for the record.
Brenda Lee Vivlamore, V as in Victor, I, V as in Victor, LAMORE, 1520 West Huntsville Ave, Springdale, Arkansas, 72764, Samaritan Community Center.
Thank you.
all right. Thank you both very much. All right. As I've tried to do in the past, I've tried to synthesize this claim down to figure out exactly what issues are in dispute. So if I'm going to start with you, Miss Mayo, Miss Lucier Mayo, before we actually get to your proof. When we were here previously, you were seeking the return of numerous DVDs. You also subsequently made a claim for a cross that had some ashes of your daughter.
Yes.
And apparently you made one of your amended complaints alleges some payments of rent. Is that correct?
Yes, and refund of removal of property, such as the mattress.
All right, so
And
expenses related to just throwing things away?
Right, and the oil.
Heating oil?
Yes, Your Honor.
All right, and at one point there was a mention that there were up to 400 DVDs that you were claiming that belonged to you that you no longer have.
Yes.
Is that still your
Yes.
claim?
Yes, Your Honor.
All right, and we'll hear more about the cross with the ashes later, I'm sure. And what are you seeking in rent that you claim you're owed?
I believe it's 219. Shoot. Let me just get to that. There's a lot of paperwork. I believe it is $219.
And what are you seeking in expenses relating to the clean out?
75.
And the fuel oil?
Well, the going rate had changed. So I believe I had put $424 currently. That was as of the last documentation.
Okay. So why don't we do this? Take it one item at a time. Now, just because I've got a couple of self-represented litigants here, so I just want to emphasize that Miss Lucier Mayo, you are the plaintiff,
Yes.
and therefore you have the burden of proving every necessary element of your case by a fair preponderance of the evidence. So therefore, if it becomes a coin flip, I can't tell one way or the other whether you should win or whether you should lose. You haven't sustained your burden of proof, so in that case, you lose. If something is not mentioned, I don't have any evidence, therefore you can't collect upon it. So you do have the initial burden of proof. So what I like to do, instead of getting your entire case thrown at me at once. Why don't we take it one major group of items at a time? For instance, we'll take up the DVDs first. You'll make your claim. I'll turn to Miss Vivlamore. She'll give her version of it, and then we'll move on to the next item. Would that be agreeable to you? Lucia Mayo?
Yes, we can do that. But first, I need to bring something to your attention. I emailed Josh Lacey on Friday because the defendant stole a password and my BJ's account. I was not aware of this until I went to renew the account. I cannot change the information. I have to actually go to BJ's to do it. And I do have the proof because she changed the address, and the address is 1605 Madison 6041, City, Elkins, Arkansas, zip code 72727. And the document is right here.
Yeah, put that down for a minute. All right, that's not part of the case. If as we get through the
I
items
just was,
you have, let me speak now. If we get through the items that you are claiming, perhaps we'll take this up at the end as maybe part of some sort of global resolution, so we don't have anything else hang over us. But since it's not part of any of your complaints, and by the way, I'm being very charitable in calling them complaints. They're not typically what we see in a civil action. This is more of a dissertation. You throw everything in. I'm supposed to figure out what you're claiming. So it's a little bit different than we typically see. So that's why I'm trying to get some format here. So my proposal is we take one major item at a time. And I'm also going to propose to you both that we dispense, typically, for instance, Miss Lucia Mayo, you would testify. And then after you're done, Miss Livermore to have a chance to cross-examine you. And then you call your next witness and he or she might testify. Instead, I'm just going to let you speak for a bit, and then I'm going to turn to Miss Livermore and get her point of view or her response, if any. And I think that might be a more efficient way of running this. Starting first with you, Miss Lucia Mayo, is that agreeable to you?
Yeah, that's fine.
All right. And Miss Brenda Livermore, would that be agreeable to you as well?
Yes, Your Honor.
All right. So let's start off with the DVDs because it's just top of my list. In the complaint, it made an allegation that 400 DVDs were purchased over time. They belong purportedly to Miss Lucia Mayo. Miss Lucia Mayo claims that Miss Viv Livermore ended up with them and she wants them back. Is that a fair summary of where we are, at least on that claim, Miss Lucia Mayo?
Yes.
All right. Miss Livermore, your response to that?
My response, Your Honor, she didn't even own 400 DVDs. And secondly, when she originally put the complaint in, she was saying to the court that I took some of her DVDs, that the list I took, which we didn't have one, because once DVDs disappeared, we were going to start a new one. And now she's saying she has a list and there's 400 DVDs. I only took my DVDs. I've been telling her this from day one. I did not touch her DVDs. I left all her DVDs where they were.
Okay, let me stop you there. So what I'm hearing from Miss Lucia Mayo is you took her DVDs. What I'm hearing from you is, no, I didn't. I only took my own. Is that a fair assessment of your position, Miss Evelyn?
Yes.
All right. Miss Lucia Mayo, do you have any further proof that you did have additional DVDs that you believe Miss Livermore ended up with that were yours and not hers?
I had an eBay account years prior to even knowing the defendant. You do have in the binder some of the purchases through eBay. which I purchased DVDs. Let's see. We did not move in together until 2010. And prior to that, I purchased a bunch. I mean, many. You have a letter from Casey Terranova. You have a letter from Beth Webster stating that I had an extensive DVD collection. Brenda, I'm sorry, the defendant, had moved out twice, and even during those times, I purchased DVDs. In the letter from Beth Webster, it stated that my daughter and her had purchased the Twilight series because the defendant had taken it with her when she left. I don't know what she did with the one that she had taken with her. But now when she moved out, well, when she packed, she took that set with her.
Your daughter
I'm
did.
going to say, as of this date, I do not want it back because my youngest daughter has purchased me another set.
Okay.
I mean,
So,
there have been many series that I have purchased. Do I have proof of them now? No. For the past 26, since 2001, I started purchasing them. Do I have all the receipts from that year? Absolutely not. There's no way I could. I mean, I had, right in 2024, I purchased Peppermint, the movie Peppermint, which I absolutely loved. And she took it.
I don't remember.
So, I mean, these are just certain things that she has taken. Certain
all right.
ones. But like I said, there's no way I can prove 25 years of DVDs that I purchased, plus series. And I did have the ones that she took, it is over 400 because the way it is the defendant had purchased these DVD holders, which they had sleeves in them, and you could put double DVDs in them. You took them out of the case and you put the DVDs in these sleeves. There was 4 of those, I guess, I don't know what you would call them. I'm going to call them containers, but they were soft cloth. And I have 2 of them. Well, actually 1.5. And I do have some movies in the cases. But the defendant took 3 of the black cloth containers with the double-sided. Plus, she took series. Can I prove it? No, of course not. But like I said, you do have the letters from Casey Terranova and Beth Webster, which they testified that I did have an enormous DVD collection, and she did take 400.
All right, let me just respond to that before Miss Biddlemore does. you see, let's take it as a given that you had those DVDs. The burden is going to still be on you, however, to show that
I know,
that Miss.
I do.
And as you said quite candidly, and I appreciate it, you know, can I prove it? Of course not. And that, unfortunately, that makes it an uphill battle for you. Let me turn to Miss Livermore. You've heard from Miss Lucia Mayo that she had a lot of DVDs. She believes she doesn't have nearly as many now as she used to have. She believes that you ended up with a lot of her DVDs. Would you care to respond to that, Miss Livermore?
Your Honor, I swear on the Bible, I did not take her DVDs. And as far as the ones that she talks about being in cases that stand up in alphabetical order, sleeves, she has all three containers. I do not have them. She took them from under the TV stand and brought them into her room before I could get my DVDs out of there.
All right. I can just tell by the look on Mr. Mayo's face that she disagrees with that. But to summarize the salient points of what you just said, Ms. Livermore, you're denying that you took any of those DVDs that belonged
I did
to Miss
not
Lucia
take
Mayo?
any DVDs of Miss Lucia's. And she mentions a letter from Beth Webster and Casey. I finally, on the 13th, when we spoke, I did not receive the certified letter. I got it on Friday. And none of those letters are included in that packet at all. I do have 2 letters that she included from neighbors that we both jointly helped out. She did more, and she was over there more, but we both would get the same. They have nothing bad to say about me because I was always pleasant too. I just didn't involve myself with people like Miss Lucia did.
Okay. But ultimately, these statements from witnesses, whether you have them or not, none of the witnesses, for instance, are going to be able to say, I saw Brenda Livermore leave that day with 160 DVDs, which were not hers. I mean, they may be able to say, I know that Betty Lucia Mayo used to have DVDs, but none of those witnesses are going to be able to say what became of them, or really shed any light as to whether you, Brenda Livermore, took them. So just focusing on that issue just for a bit longer. Do either of you, well, starting with you, Mr. Lucia Mayo, because again, you do have the burden. Do you have any further proof that Miss Livermore has the DVDs that you believe belong to her?
You know what? I don't have proof, and she'll have to live with it.
Okay. Let's move on to
I
something a
do
little
have
bit
a
easier.
comment, Your Honor, in regards to her stating she didn't get the certified. I spoke with Iris. I can't really say her last name. Greeno or something. I can spell it for you, and I actually have her phone number. Miss Livermore did not sign for the documents, which was certified restricted. Miss Livermore was supposed to sign for those documents. I have proof she did not sign for them. As of last Thursday, the documents had not been picked up. But like I said, she didn't sign for them. Were they opened by someone else? I don't know. Were documents taken out? I don't know, because the defendant did not sign for them. Someone else did.
Okay. Let's get back on track a little bit. The next item that might be a bit easier to address is that you claim that Miss Livermore owes you $219 in rent. Could you give me some basis to that, ma'am?
I have a housing voucher through TVCCA. All rent needs to be paid. If not, I can lose my housing voucher. The defendant did not pay her rent for November. It had to be paid before I signed a new lease.
So the housing that you had, did the TVCCA know that both of you were residing there?
She knew until she knew that the defendant was staying there until the end of the current lease, which ended at the end of November.
And was she on the lease?
She was until that point.
All right, so you had a month-to-month lease, or did you have a year-long lease?
No, it
Ms.
was a
Lucier?
yearly lease.
All right, so you're saying that based on your financial situation and Ms. Vivlemore's financial situation, TVCCA determined what you would pay in rent each month. Is that correct?
Yeah, it was determined, it was based on our income. Yes.
And then, so you're saying that, so let's say the number was $450 a month that the two of you had to pay. You're saying when she left unexpectedly that you were left paying the entirety of the rent for the month of November?
Yes, I did.
Okay. And you're saying that her one half of that rent would amount to $219?
Yes.
All right. Ms. Vivlemore, would you care to respond to that?
Yes, Your Honor. I had went to the landlord and explained to him that Miss Lucier was badgering me on a daily basis and that I had to ask him to put a lock on my door. I was not able to utilize the house, renting the house together without conflict. I couldn't even go to the bathroom without fear. And I had went to him and I said, I really need to get out of here. Can I get my security back? You do a walkthrough and I get my security back. And he said he could not do that, that if I don't pay the November rent, it would fall on to Miss Lucier, or I could ask Miss Lucier to give me my security deposit back and see if she'll do it. And I knew she wasn't going to do it by all the accusations, because I had paid half of the security deposit too. So when it came time to finally move and getting closer to the end of the month, I decided that she was going to eat the $219 because she would not give me my security back. And I used that to help get me out of there, that she kept on yelling. She wanted me out. She wanted me out. Or I'm going to keep on doing this until you leave. I'm going to harass you. I'm going to keep taking you to court until I get what I want.
Okay, so let me just make sure I can fine tune that a little bit. So you did leave the apartment and leaving Miss Lucier Mayo responsible for your half of the rent because you felt somehow that would be compensated to her based on her not giving you your security deposit back? Is that sort of the
Yes.
gist of it? But you got to
Yes.
understand, she wasn't holding the security deposit, was she, Miss Vivlemore? No, the landlord would be holding that.
No, but he said that once I left, he would immediately give it to her. It wouldn't go on to the new lease. She would be signing a new lease. She's
Right.
just going to take that money and put it back into the new lease.
She being the landlord? Or Miss Lucier
Miss
Mayo?
Lucier.
Well, you see, here's the situation. If while you were on the lease, you would agree to pay half of it, which I gather is $219, and Miss Lucier Mayer was going to pay the other $219, and you'd be responsible for that up until the end of the month in which you moved out. So when you moved out and the new lease was signed, and assuming there was no damage done to the apartment or other, things along those lines, you would then be entitled to one half the security deposit back. But that would be between the landlord and you. That wouldn't be between Miss Lucier Mayo and you.
That's
So
not what he said, because he said I've been told for the past 20 years, it's her HUD voucher. And then when December, actually back in 2024, I was planning to move out by December 1st. Miss Lucia convinced me not to go, that things were going to change, blah, blah, blah. Well, when I decided I was going to leave this time, I had called the HUD voucher place and I explained to them what was going on and that I needed to get out. And they said, that's between you and Miss Lucia. She is the HUD voucher. I can't offer you any help. I can't get you a voucher. I can't do this. I can't do that. It all falls onto her. When I went to the landlord, he said, it does not fall onto me. It falls onto Miss Lucia. She's the holder of the HUD voucher. So the security deposit goes back to her in full. And it's up to her to distribute your security deposit back. And he would not take any liability whatsoever. So at that point, I said to him that I was not going to pay November and let her pay it. That way I knew I got my security deposit and that I was out of the house like she was pushing me out and not paying for a house that I had access to the bathroom, the refrigerator, and the shower and my room, and not the rest of the house.
Right, let me interrupt. What was the amount of the security deposit for both tenants?
At the time, it was 707. It ended up being 503.50 that we both paid.
All right. And Miss Lucia Mayo, do you recall what the security deposit was on the apartment?
Yes, the security deposit is $1,007.
Thank you. It was what I knew I couldn't add fast enough.
Okay, so you're pretty close there. You're actually right on the money. So 503.50 each, or 1,007 combined. All right, and Miss Lucia Mayo, when you signed a new lease, well, I'm assuming after Miss Villamore moved out, did you sign a new lease?
Yes, I did.
All right. And at that time, did the landlord or TVCCA give you the security deposit back on the prior lease?
No,
Did they just apply it towards the apartment for the new lease?
it just continued on.
right.
Your Honor,
And
the defendant just told you a great story, and I am willing to put my landlord on the phone right now.
Okay.
If I knew that she was going to say these things, I would have had the landlord here as a witness.
Okay, here's what I'm hearing so far, is that if each of you had a security deposit of $503.50, and Miss Livermore, you're saying you never received any of that back, correct?
No, I did not.
All right, and it said, Miss Lucia Mayo, it sounds like they applied Miss Livermore's $503.50 towards the new security deposit. So therefore, if she owed you $219 and she was entitled to a security deposit of $503.50, she actually came out a bit behind on the deal by doing the transaction the way she did. Now, I would say that that's not the way you probably should have done it, Miss Villamore. Legally, quote, I decided she was going to eat the $219, close quote, is not the way we work out security deposits.
I understand that, Your Honor, but I'm also on a fixed income.
I'm just telling you that was the situation is, ladies, is that if her security deposit, which she no longer has any claim, was applied towards your current security deposit, Miss Lucia Mayo, then you actually came out slightly ahead on that deal. So I would say
I did it. It's still with the voucher. That's what it's with.
Yeah, but
It
if
was,
she
it's
had a
with the
security
original
deposit,
lease.
tell me if I'm wrong on this. Her half of the security deposit was $503.50. True?
She paid some of it, yes.
All right. And she did not get that back. Is that correct?
No, it was,
So,
the landlord could not give it back to her.
okay. All right. And it instead went towards the security deposit for the new lease that you signed after she moved
No.
out, correct?
No,
All right. So I guess there's the rub. All right. So,
But she just, Your Honor, she just said that it was applied. She literally
Yep.
just said to you 2 minutes ago, it was
yeah.
applied.
All right. Let me just, so when you signed the new lease, Miss Lucia Mayo, who paid the security deposit for the new lease?
it did. Okay, the security deposit was not a factor because I continued with the lease. The only thing that changed was that the defendant was no longer on the lease. That's it. That's the only thing that changed.
Well, what didn't change was you had $1,000 and $1,007 security deposit. After you signed a new lease, you still had a
It
$1,700
was,
security deposit, correct?
it was a continuation of lease. That's how it works with TVCCA. It's just a new lease that's signed every year.
Got it. But you didn't pay, you ended up with a fully paid security deposit under
I
the new
guess so.
lease, right? Which you didn't fully pay because some of that money came from Ms. Livermore. So my
But she
suggestion
left.
is, yes, if you ended up on the good end of that deal, and therefore it more than covers the $219 that she owed you for the month of November. Do you see that?
Okay, well, she left damages and she still didn't pay for oil.
We're gonna
So,
get to the oil.
and she didn't pay for
We're gonna get to
the
it. I'm just doing
property.
one thing at a time, man. Bear with me.
Where did she's not here anymore.
Yep, we're gonna pause for a second and let her come back. There you are.
It all of a sudden kicked me out.
Well, it happens from time to time. All right. So now, when you rejoined us, Miss Livermore, we've got the echo again.
Yep.
Would you mind logging off and logging back in?
Okay.
She's got to hear. Cigarette.
No. Still getting over them.
Bronchitis.
Pneumonia.
Better?
Let's see. Yeah, it does seem to be better. All right. So the next thing on my list, at least, is the oil, in which Miss Lucia Mayo is claiming that Miss Livermore owes her $424 for fuel oil. Miss Lucia Mayo, would you care to elaborate upon that a little bit, please, ma'am?
Yes, according to the lease. When we moved in, the oil tank was to be at half a tank upon move out, because it was at that when we moved in. There is a 500-gallon oil tank here. So that would be 250 gallons that would be have to be split. I would be responsible for 125 gallons. The defendant would have to be responsible for 125 gallons, which would equal the 250. And that's on the lease.
And how many gallons were in the tank when Miss Livermore left the premises?
I have no idea. The tank was not looked at.
But you see, that's the problem. Is let's say, just for instance, let's say the tank was half full when she left. That means when she moved in, it was half full.
I know it wasn't.
But that's what I need. I just asked you how full or how empty was the tank. You got to give me some answers to that.
Oh, okay, so now she's not going to be responsible for her oil?
Well, no,
because
you have
what
to
it
tell me.
is,
Suppose that tank
Your
was
Honor,
full when she moved out. She left you in
it's
a better position.
It's not when she moved out. It's to be when everybody moves out. It's not upon her moving out. It's when everybody moves out, according to the lease. When she leave, it had to be 100. Her part is 125 gallons. Period.
Okay, but what was it? Because you signed a new lease after she moved out, correct?
Mm-hmm.
So at that time, there should have been 250 gallons in the tank, correct?
So I was supposed to go and take a picture.
Well, you can't just make up a number. You just can't say, I'm assuming it was empty.
Okay.
Nor can she
Never
assume
mind.
that.
Forget it.
Okay. Oil's off the table then. All right. So that leaves us with, looks like the main issue that we have left is a sentimental issue, because I recognize that
No, I still have, there's still items.
All right. And what would they be, ma'am?
My mother's items. Zola's bed, Zola's kennel.
All right, now go slow here. Who or what is Zola?
Zola is my dog.
Okay, is that Z-O-L-A?
Zola, and it's Mae. Lucia Mayo. She's a dog. And that's how this started. This civil suit started because the defendant did say she was taking my dog.
I did not, Your Honor.
But she's going to deny it.
Right? She said it, but did she end up taking your dog?
You're echoing and I can't understand you.
All right. Miss Livermore, would you turn off your microphone while we're just a microphone? All right. Did Miss Livermore take Zola with her when she moved out?
No.
Okay. She
But the
threatened
civil
to, but
suit
she
was
didn't do
already
it.
filed.
All right. So we're not. So you say she took Zola's bed and kennel?
Yes.
All right. And did you have another dog? The two of you? Were there two
yes,
dogs?
Dash Michael. He's a Chihuahua mix. He's a
All
small
right, so
dog.
you had Zola and Michael.
Dash.
Dash.
Yes.
I'm still not sure. Is it Dash Michael or Dash?
Dash Michael.
Okay. So you had two dogs, Zola and Dash Michael. When she left, she took Dash Michael with her, correct?
No.
No.
She
Okay.
left Dash.
So she left both dogs, Zola and Dash Michael?
They're both mine. They are
Okay.
both here.
But she said, but you're claiming she took one of the dog's bed and kennel with her.
Correct.
All right. Miss Livermore, would you mind? Okay, turn your mic back on. And tell me, did you take the bed and kennel that belonged to either Zola or Dash Michael?
No, I did not, Your Honor. I purchased 2 small beds because I bought all the stuff for the dogs. I purchased 2 small beds. One was for Dash, one was for my Gibbs McGee. My Gibbs McGee didn't like his bed, which was the exact same as Dash's. So Dash got Gibbs's bed. I had purchased 1 bed for Zola and 1 bed for Bella. The one for Bella was too small because Bella's a bigger dog than Zola. So I purchased another queen size that was extra, extra large for my Bella so she could lay out flat on it. Did Zola use it? Yes. Was it Zola's? No. And the one that I had originally bought for my Bella went to Gibbs because he didn't like the real small cooped up one. So she ended up with 3 beds for 2 of her dogs. She's trying to take my Bella's bed, saying it was Zola's because Zola liked it.
All right. So what you're saying is the bed that you took was purchased by you for one of your own dogs.
Yes, and the kennel wasn't Zola's. It was never Zola's. The kennels that I had, neither one of our dogs slept in them. They were for fosters, and they were used for fosters. And when I didn't foster anymore, I put them up in the attic, on the clean side of the attic, I call it. It's like a bedroom. And when I left, I did take them because they were mine.
All right. Did you purchase the kennels?
Yes, I did.
All right. Let me turn back to Miss Lucia Mayo then. So what I've just heard was that Miss Livermore claims that she purchased the beds and that the large queen size bed is one that she purchased for her own dog and therefore she took that with her. Do you dispute that?
Yeah, I do. According to even her own documentation, that through Chewy, I guess it is, she had purchased 2 jumbo beds, and even in her own words, purchased for Zola, purchased for Bella in her own documents that I have a copy of.
Okay. And just let me clarify, Bella is her dog, correct?
Yes, correct.
So she purchased a bed for Bella and she took a bed
jumbo
with her.
size bed.
2 large beds.
No, don't interrupt. Let me just, too confusing remote. So if she bought a bed for Bella and took a bed with her, what's wrong with that?
She took both jumbo beds. One was Zola's and one was Bella's. She purchased 2. She had purchased one for Bella and one for Zola.
They weren't jumbo.
And
Let me speak for a second, folks. Just get to the point. You can't enforce a gift to an animal. So if Miss Livermore, quote unquote, gave a bed to Zola or to Dash Michael or to anyone else, then she still owns the bed. She's just allowing the dog to use it. It's not like the dog has then acquired ownership rights to the bed. It certainly doesn't mean that you, Miss Lucia Mayo, obtain ownership rights to a bed. Now, arguably, if she gifted you the bed and then you decided that one of your dogs was going to use it, then you could argue whether it was a gift. And even that would be difficult because then you have to show the gift had some consideration in order to be a binding contract. But basically, if she bought 2 beds, one for her own dog and one that ended up being used by Zola or Dash Michael, she's still the owner of the bed. She could therefore take it with her when she moved out. I mean, you know, I don't know if she, typically whether somebody would do that if another dog is sort of claimed it as its own, but nonetheless, if she bought it, she can take it.
The standing agreement was, I paid for household bills. I paid for taxables. I paid car insurance. Yes, it was my vehicle. I paid for her life insurance. I paid for vet bills, and she would buy things for the dogs. Therefore, Zola's bed is also mine because I paid for household bills, lights, everything, and she didn't pay them. That was a standing agreement, and it's in her own words, in her own documents also. So when she paid for the dog things, it was also my things. As when I paid the bills, she was also paying them in a sense. Because
Just
we
out
were
of
together.
curiosity, what does a queen size, jumbo size dog bed, such as the one that's missing, how much is that worth?
I would have to look at her documentation.
Just approximately.
I think
$9 was the jumbo, and $50 was $50 or $55 was the two large ones that I purchased. I only bought one jumbo because I only have one jumbo dog.
And how much was the jumbo, ma'am?
The jumbo was $109.
Okay. So the bed that turned up missing, I'll just characterize as
her own
that.
documents.
That's $109 bed.
Her own documents.
Okay. I'm getting a nod from Miss Livermore. So.
Yes, Your Honor.
Okay. All right. So we have a dispute as to the ownership of the bed that disappeared. That's
kennel.
worth $109.
And the
All right.
kennel.
And the kennels. And you purchased the kennels, Miss Livermore?
Yes, Your Honor.
You dispute, Miss Lucia Mayo, that Miss Livermore purchased the kennels?
No, I'm not disputing it. What I'm disputing is the fact that I paid what I was supposed to pay. We had the standing agreement that I would pay for those things and she would pay for what the dogs needed.
Okay.
Can I say
And
something,
it's
Your Honor?
just 1 second. And there were 2 kennels that were up in the clean area of the attic?
And yeah, she had one for Bella and one for Zola.
And the approximate price or value of those kennels would be what?
I
Either
got
of you
both
know?
of them for $70.
Combined?
Huh?
Combined. You got 2
Yeah.
of them for $70.
Yep.
All right, let me turn now to I realize an item that's got some sentimental value to both of you. And therefore, it's not just simple arithmetic. My understanding is from the pleadings is that Miss Livermore was given a cross which contained some ashes, which I believe were the ashes of Miss Lucia Mayo's daughter. Do I have the story correct?
Correct.
All right. And my understanding again from the pleadings and the allegations and especially the answer alleged by Miss Livermore, she's claiming that a third party gave her the cross. It did not
No.
come from Miss Lucia Mayo. That's at least
Oh,
what I'm.
no.
Okay. So let me, since you're the plaintiff, Miss Lucia Mayo, you tell me the history leading up to Miss Livermore having the cross with the ashes in it. And it's just one cross, correct?
Yes.
Okay.
It doesn't.
And I don't want you to have to go into the loss of your daughter. My condolences in that regard, by the
No,
way. But let's just
I'm
take
not
that as a
going to
given. Your daughter passed, some ashes were
Yes.
then available, and what happened then, resulting in those
Um,
ashes ending up in a cross?
I purchased I purchased 2 crosses and a heart, and asked the funeral director to place my daughter's ashes in them. Yes, one was given to the defendant, but the defendant, every chance she got, put my daughter down. And made false statements against my daughter, and she's not here to defend herself.
All right, let me just backtrack so I understand. These statements were made before or after your daughter's passing?
Actually, there was some. She called her things before she passed, but after she passed away, she did.
All right.
And there's documents at the Putnam Courthouse.
So you had 2 crosses and a heart made or filled by the funeral director, and which of those ended up with Miss Fiddlemore?
It's
one cross?
One cross, yes.
And how did she get it? Did you
Excuse
give
me?
it to her?
Yes.
Okay.
I am the rightful owner of the ashes, which are inside that cross.
You would have been, I presume that, you know, you're in charge of your daughter's estate. I don't need to get into that aspect of it, but assuming that the ashes belong to you, and then you had the funeral director do something with it, then from what I'm understanding is you then gave one of these crosses to Miss Vivlamore. So once you gifted it away, what is your contention that you still owned it?
The way she has treated my daughter previously and after her death. And because of the number of things that she has stolen. I mean.
So what I'm gathering then, ma'am, is what you're saying is that based on what happened thereafter, you had a change of heart and you
She does
wish you
not
had.
deserve it. They are
Okay.
my daughter's ashes. I want them back.
Well, here's the situation. You gave it to her. If she wants to
I
give
gave
it
her the
back,
cross, not my daughter's ashes.
well, the ashes were inside the cross, right?
I want my daughter's ashes back.
Okay.
She doesn't deserve
Um,
Your Honor, somebody's speaking in the background and it's.
yeah, it's not distracting me yet, but I agree. We can make it easier if we don't have too much of that. All right, I'm trying to be understanding, Miss Lucia Mayo, and I certainly understand your feelings. You and Miss
I
Vivlamore
have the
having,
receipt. I want them back. I want it back.
well, you just might want a lot of things, and you may just not get them back, man. I'm trying to be diplomatic about it, but you gave that cross with the ashes away.
She
You
gave
made
me a
that decision.
65-inch flat screen TV. So I want that back.
Let's focus on you
Well, I'm
can't
just
just
saying.
have a change of heart thereafter and say, well, now that we're broken up, we're no longer, you know, we're no longer together, you know, I'm taking back what I gave you previously. That's just not the way it works. All right, do we have, what other issues are in dispute between the two of you? Well, that's a dangerous way to put it. I want it limited to the complaint. I don't need to hear any other disputes, but in the complaint, have we covered all the items
Yeah.
that,
Yeah.
'cause initially this was a complaint sounding replevant, which is a fancy word for saying, give to me the goods to which I'm entitled. I have a superior right to title over the possessions, and therefore you should give them to me. So we've gone a bit beyond that with the rent and some of the other payments, but certainly some of these items could be replevant. What other items, if any, have we not addressed?
My
that you were
mother's
seeking?
vintage snowman. My mother's ice
Vintage
cream scoop. My father's knives.
I have no clue what she's talking about, Your Honor.
You're jumping ahead of things, but I was going to ask you that in a moment. But so a vintage snowman, your father's knives, and a scoop of some sort, and they were
Ice
in
cream
the
scoop.
apartment up until some point, I gather.
Yes, they were in this house until the defendant decided to pack when I was not here.
You haven't
And
seen
he
them
packed
since.
items every time I left the house.
And Miss
she's
Livermore,
left. She moved out without my knowledge.
Miss Livermore, did you take the vintage snowman, her father's knives, and the scoop?
No, Your Honor, I have no clue to what she is even talking about. I
Were
didn't
these in a
even,
box somewhere, Miss Lucia Mayo? Were they
Nope,
set
it's
aside?
gone. It's
But where
gone.
were they before? Were they in a
They
cupboard?
were in with the Christmas things. And Miss Livermore went through Christmas items.
All right, Miss Livermore, you took some Christmas things with you, I assume?
I had taken some bells of mine, tree skirt, my
All right, I don't know what, but you obviously did take some Christmas things that you felt you're entitled. Once you've since moved from there, have you opened up everything that you took from the shared apartment? What I'm getting at, are you sure that perhaps by mistake you didn't take something? Say again, ma'am?
I do not have any of her Christmas stuff. Not
Okay.
anything. She
All right.
actually has all of the Christmas ornaments that my grandson made.
Not
And
your
she
grandson.
has my white beads. And she also has three snow angels that are porcelain that my sister made me.
All right. So you haven't seen her father's knives, correct?
No,
You haven't seen the scoop that she described for us.
nope,
You haven't seen the vintage snowman.
nope.
Miss Lucia Mayo, is there anything else that you can identify that you believe that Miss Vivlamore has that you believe you're
I
entitled
have
to?
a list. Yes, my
No.
daughter's laptop, which I purchased for my daughter. And the last time I saw it was prior to my ending the relationship. She had asked if she could use it, and I had said yes, but she never returned it.
Okay.
The
Before you go on,
backpack case.
let me ask her, what happened to the laptop, Miss Vivlamore?
It's not actually a laptop because it does not hold disk or anything. It's a notepad. And she had it upstairs in the yard sale, and I was doing stuff and needed a laptop, and she has one and doesn't want me on her laptop. She said, why don't you take what I was going to sell in the yard sale? You can have it. When she said I had it erased. And she says one of best friends erased it. When I opened it up, her stuff was still on it, and she, I guess, paid somebody to erase it, and it was still on there. So I said, I will spend the time and I will erase it, which I did. But then my stuff went on it because she gave it to me, and it came with me because all my stuff is on it.
Let me just see if there's a Miss Lucia Mayo. Do you know the difference between a laptop and a notepad?
My daughter had told me it was a laptop, and that's, my daughter has some disabilities, okay? And it's a laptop that opens up. Okay, if it's a notebook, then it still opens up, so it's considered a laptop computer.
So it had a keyboard on it, ma'am.
Yeah, it had a keyboard on it.
All right. And Miss Vivlamore, the notepad that you described, did that have a keyboard on it?
It has a keyboard. It looks similar, but it's a lot smaller than a laptop. It does not have the compartment to put like a DVD. You can't do anything with it other than like go online and look at Facebook and stuff like that, or put personal letters or notes.
Okay. So it
doesn't
seems
do
like we're at least
anything.
talking about the same piece of technology and Miss Lucia Mayo says she didn't give it to you. You believe that she did give it to you. That
Yeah,
seems to be the dispute here.
we did.
Okay. Does anyone have any idea as to the value of such an animal?
Well, I bought it for my daughter for $100, but I purchased both of them with I purchased the computer, and I also got the backpack lap case with it. So
There's no with this.
So for both items, it would. I purchased it for $100. I can't. I'm not going to nitpick.
All right. Are there any other items that you feel Miss Vivlamore currently possesses that you have a right to?
Yes. I need to get my notes.
My name's Miss Vivlamore.
Did I say something wrong?
You said Miss
Oh.
Vivlamore, and she's answering.
Right. I misspoke. That Miss Vivlamore has a right to, that you believe you have a right to, and that Miss Vivlamore does not.
Where's the paper? Where did it go? Where did it go?
Your Honor, can I say something while she's looking?
You can.
Many items of mine I was unable to take because Miss Lucia either one, purchased them or claimed them, which was a roll top desk. She mentioned in her very first complaint that I had packed up 50% of the house and that I was taking 90% of the stuff. I sent in a flash drive with recordings to the court and to Miss Lucia, where I had asked her if she wanted the front load washer and dryer. She said, no, I hate them.
Okay, I read that, and that's not really what we're here about right now. But tell
I'm
you what,
saying she has multiple items of mine that are big in that house that I was forbidden to take. And I decided, you know what? I don't want to be harassed by her anymore. I don't want to be threatened by her anymore. It's replaceable at some hopefully given point. I'm leaving it. I'm done with this. And that's when I left without no warning.
okay, everybody stop. We typically take a break mid-afternoon because you're not tired, I'm not tired, but my court monitor's been typing all this for an hour and 15 minutes. I'm sure she's tired. So we're gonna take a break. Let's be back here about 3:30. We'll pick this up. Miss Lucia Mayo, if there's anything else you intend to present to me that some item that you feel should return to you, use this time just to pull that up and be ready to go.
Okay.
Okay?
Okay,
We're
and my
in recess.
witness.
Thank you.
What do you need me for? 1, 2, oh, gosh.
Hear me, Miss Lucy Mayo?
Yes, can you hear me?
Excellent. I can. Thank you.
Great.
Miss Lori Vivlamore, are you able to reach, Brenda Vivlamore by cell phone?
I can message. Can you hear me?
Yes, I can.
I can message her and see why she's not on.
If you would. I don't know
Sure.
if she misheard me when I said come back at 3:30, but we'd like to kick this off again.
Yeah, I'm hoping she didn't think it was 3:30 this time, but I'm gonna message her right now. 1 minute,
Thank you.
sir.
Time's different. 2:30. Arkansas. 3:30 here.
Oh, that's because she's got to use her phone to go that way. Yeah, makes sense. I have a very important baseball game. It's only the judge.
I'll get you to testify. Come on, guys. Sorry. Oops. I know Arkansas is an hour behind. I don't know if she misunderstood.
But is he in Putnam?
Are you in Putnam or Willimantic?
I'm in Putnam.
Yeah, Putnam.
If the defendant Brenda Vivlamore would join us, she seems to be, there we go. All right, plaintiff
I'm
ready to
sorry,
proceed?
I thought you said 3:30.
I did.
It is
Connecticut time,
3:30.
not Arkansas time. My court monitor works very hard, but she probably doesn't need an hour and a quarter break to recuperate from this afternoon.
I'm
All right.
sorry, Your Honor. And to
Lucy
the
Mayo,
court.
are you ready to proceed?
Yes. Okay. The other things are, I need the documentation to East Coast Canine Rescue and to me, for the defendant to relinquish ownership of Zolame Lucier Mayo and Michael Lucier Mayo and any papers pertaining to them from ECCR.
All right, before we get any further into that, Miss Vivlamore, do you claim to have any rights to those two dogs?
No, I don't have rights. I purchased Zola, but I purchased her for Betty Lucia Mayo. But
All
I
right.
don't have any legal papers from East Coast Canine Rescue. I just paid the fee for adoption online and she was ours. They never gave me paperwork for the dogs.
Okay. Miss Lucier Mayo, do you accept that?
I don't
No.
even have paperwork for my two dogs.
All right.
It
Well, that's
came
one of
through
those things.
email. It came through email because I have some for Gibbs, which I had emailed to the defendant. Now it's whenever Gibbs had come to the house as a rescue.
All right. Is there any other items, physical items
Yes.
you're seeking possession of?
A chain link bracelet with a picture of my daughter on it, and it's a heart with her name on it, I should say, and it has angel wings.
All right.
I have the
And-
receipt for it. I have the receipt for it from my daughter. She gave it to me, and she cannot be here today because she's an EMT, and she's always getting emergency calls.
Miss Vivlamore, what is your position as to the bracelet with the heart name
Your
and
Honor,
wings on it?
I want to bring to your attention something. When we talked on the 13th, which was a Monday, Miss Lucia had said to you in the court hearing that her daughter, Katie Webster, did not want me contacting her, and that I'm not to ask her to be a witness, which I did, she claimed, and that she doesn't want anything to do with me. On one occasion, Lori Vivlamore is the witness to this and can verify this. Katie had reached out to Lori and was sending my sister-in-law pictures and update of my grandson that has known
Not
me
your grandson.
as Nana since the day he was born. And Katie told my sister-in-law that she could share the pictures. Shit. Oh, I got kicked out. Oh, no, I didn't.
Does this have anything to do with the bracelet, ma'am?
Yes. That she could share the pictures and have me contact her. I did reach out to Katie, and we talked several minutes. She sent me pictures. She told me about her surgery, how my grandson was doing, that he's 4 feet 8 inches and moving into the 5th grade.
Bracelet. Talk to me about the bracelet.
I then asked Katie, because Miss Lucia keeps on bringing her up in the court and the bracelet in the court. I had asked Miss Katie, I'm trying to find the page. I said, I said thank you to a comment she made. And I said, I have to ask this. Did you ask for the bracelet you gave me for Christmas with Ashley's picture on it back? Then please no more talk in regards to it. I just want to know the truth. Bert, if you did ask, it's okay. I just need to know from you. Sorry if I upset you. Her answer was, I'm not answering anything about that. It is a boundary I have in place with her and you. She is not discussing anything about this court case or anything that her mother wishes in this court case with her mother, as she refuses to do so with me.
Okay. Talk to me about the bracelet.
The bracelet I do have, it was given to me after Ashley's passing. It was ordered by Katie Webster, the EMT, Betty's daughter, as a Christmas present by Katie Webster. And that's why I asked Katie Webster. In our communication went on all the way up until July 4th.
I don't have
So the gist
documentation
of all
of
that
that.
is that you're maintaining that Katie gave it to you as a Christmas present, correct?
Yeah.
All right. Miss Lucia Mayo, what is your position in regard to that?
I don't have any documentation of that.
Your Honor, she
But-
did not
Yeah,
get
but
the
you,
call.
the burden, ma'am, the burden's on you, Miss Lucia Mayo, to show that you've got some right superior to that of Miss Vivilmore
I
to the
have the
bracelet.
receipt which my daughter gave me. Your Honor, I think what's gonna happen is I'm gonna have to have an appeal, and I'm gonna have to have a string of witnesses. Beginning with the landlord, and my daughter will be subpoenaed, plus mutual friends will be subpoenaed. Other people will be subpoenaed to testify on my behalf.
Outstanding. That sounds
Your
good. Go ahead, Miss Vivilmore.
She has had ample opportunity.
No, ma'am, let's not get into that. We're here about evidence. What else do you propose to me, Miss Lucia Mayo, that you are entitled to?
I'm just going to turn the page. The defendant moved items out. She stated she was putting them in, that she put them in a storage unit. They were not put in a storage unit. She ended up putting them in her daughter's apartment. Her daughter's name is Renee Vivilmore LaFleche. I found out that there are items that the defendant left there. So with the items that are missing, and the defendant is claiming she doesn't have, with items being left at her daughter's apartment, therefore I believe possibly her daughter's in possession of them. So I am sure that her daughter is in possession of stolen property, and I will probably be filing a police report that she's in possession of stolen property.
Is there anything else you'd like to offer in the way of proof that Miss Vivilmore, Brenda Vivilmore, has something that belongs to you, ma'am?
The other thing I just want to mention is in regards to these items that the defendant has mentioned that she has left. In the documents filed on November 3rd of last year, 2024, and August 26th of 2024, that she was leaving items. She moved out, she left items. She abandoned the property.
Let me just stop you for a second. You're talking about documents that were filed in 2024?
Yes.
This action was filed in 2025, correct?
Yes.
No, this action was filed, the civil action was filed in August of 2025. I'm sorry with the year. It was 2025, yes.
All right, so go back, tell me, you're referring to various documents that were filed.
Yes, in August 26th. I need a drink.
Okay, in August of 26th, the defendant filed an answer.
Yes, and she said she was leaving these things here. And then And it was because, I wasn't going to give them to her. We never had any discussion about any property. None. She just packed and took what she wanted. Number two, on November 3rd of 2025, on the filed documents, she was leaving items. So, and then she moved out end of November. And she had, November 3rd, she had filed that she wanted these items. And this is in her counterclaim, that she wanted these items. Well, she left them, she moved out, leaving items, and now wanting monetary money. It's not going to happen because she left them. She left her dresser. She left TV trays. What else? And
Yes.
you know, it's you know, she abandoned the property. I'm not gonna. I can't be. She want money for them. I'll put them out in the yard sale. No problem. Not putting out my recliners that I paid for though.
All right,
Even though she abandoned the property, she can't have the cake and eat it too.
all right, we're not here about any claims by Miss Vivlamore. We're here about your claims. Are there any
Well, I'm
additional
just saying.
claims you want to? You're just saying, but I want to hear about claims that you have that I can
gave
address
them to
today.
you. I gave them to you.
All right, so
That's
you're all
it.
set with your case?
Oh, there is one more. The defendant has my Christmas ornament and I have hers with the name on it.
I don't have any of your Christmas ornaments.
Okay, then I don't have yours.
Is there anything else you're claiming that Miss Vivlamore has that belongs to you, ma'am?
Not at this time.
All right, do you rest your case then?
I do want to call my witness.
And what would the purpose of your witness be? It's called a proffer. What,
My mother's
what
items.
what is your witness? Give us a synopsis of what your witness
She's
can
going to testify that I don't get rid of my mother's things. Everybody gives me my mother's things and I do not get rid of them. I
All right,
save
but
them.
how does that go towards your burden of proof that Miss Brenda Vivlamore is somehow responsible for something being missing?
Okay. That's fine.
Okay.
Yep, that's fine.
All right. So are we done with all the claims between you two litigants?
Your Honor, all I would like to say is that I want this done and over. I want to go on with my life. I did leave stuff in fear of Miss Lucia and told that I could not take them. I ended up not taking them just so that I wouldn't have this. And even with the BJ's card, I cut my name off it and gave her the BJ's card. I did not in any way have an account opened under my name or change any passwords or anything. The king size mattress I left because it was hers.
Was not mine.
And she was sleeping on the king size mattress in the king size bed that I bought. I was sleeping on a day bed.
All right, ma'am, let's just stay focused. You've heard Miss Lucia Mayo make some claims. I've given you an opportunity as we've gone along to rebut those and to give us your point. Is there anything else you want me to hear regarding her claims against you?
My witness.
And what, if you have nothing to tell me, what is your witness going to tell me, ma'am?
She can verify everything I'm going to say. Is that I did not take, the kennels were not Bella and Zola's. They were for Foster's. I did not take her stuff.
She can't testify as to what you did or didn't do unless she was with you every moment of the day when you were there and thereafter. So
she was on the
what
phone.
is this? Yeah, but you don't need a character reference right now. Somebody saying, I don't do these type of things, or that she doesn't believe you
Okay.
did it. That doesn't work.
I'm just frustrated because I know before I left, she told me she was going to take me to court and take me to court and take me to court until she gets what she wants. And she just proved it by saying she wants to appeal this.
And that's something I have no say in. If somebody wants to appeal something, they can always do it. The appellate court will make quick work of the appeal, or it won't. It's up to them. But I just want to make sure that I give both of you, I want to give Miss Lucia Mayo a chance to present her claims. I want to give you a chance to address those claims. And once that's done, the evidence is closed and I'll start working on a decision.
And
Miss Lucia Mayo's indicated she's set. Are you also set? Miss Vivlamore? Ma'am? Are you all set with this trial, Miss Vivlamore?
I am. Your decision will be heard if she appeals this?
No, the way it works is, once this case is over, I then write a decision. I say party A or party B wins, or party A wins, or I make my decision. I put it in writing. You both get copies of it. And then if either side isn't happy with it and they feel there's grounds for an appeal, you can take an appeal.
Okay,
Okay, are we all set then?
all set.
I have
you both
one
today.
question. I do have
All right.
one question. If she does have to give me things back, I am not going there to get them. She needs to send them to me because she chose to move there. And I'm not sending items to her. She chose to move there.
We're putting the cart before the horse, because I haven't decided whether anything
I'm
has to go
just,
back and
you
forth.
know.
But were that to be the case, I would put an extra line or two in the decision that, items are to be sent UPS at one party or the other's expense. We'll work something out, but
The reason why I said that, Your Honor, is I cannot send anything to this community center. She cannot sign for a certified letter.
ma'am, you're claiming that she has things that you are entitled to. So you're seeking her to send things to you. So let's not worry about you trying to send things to her. Okay?
Yep.
All right. Evidence
Thank you.
having concluded, we're all set for today. I'll get
How
a
long
decision
does it
out.
take?
I'm going to tell you, it doesn't come out right away. I have 120 days. I'll try to get to it sooner than that. I'll try to get to it much sooner than that, but there's no guarantee. And then this matter will be behind us all.
Okay, thank you.
Thank you.
Thank you very much, Madam Court Monitor, Mr. Clerk. Thank you very much as well.
I had to get in touch with state police.
Hmm?
I'm gonna have to call the state police.
Can I go home now? And put yourself in better paperwork.